Mrs. Rutter.
My Lady and my Lords, may I move on then to look at the first of the 4 points that we identified before the luncheon adjournment, and that is the interpretation given by the Jersey Court of Appeal to Article 1 of the Children Law Jersey. And may I invite the Court to look at the statute itself, which is at tab 1, MS 522. And there are 2 places in the statute where the statute sets out who is considered to be a parent. First of all, in the definitions part under Article 1 itself, or interpretation part under Article 1 itself, page MS 530, parent includes the father of a child, whether or not he was at the time married to the child's mother, and the biological father of a child where he has been granted parental responsibility under Article 5.2. The second place in the legislation where the statute considers or sets out who a parent may be is at paragraph 13. And that is MS 542. And it provides that a parent, paragraph 13b.
Article 13b.
Yes, forgive me.
Sorry?
It's 35th, the schedule.
It's MS 600.
That's more like it.
600.
Yes.
We're in the schedule, aren't
Yes,
we?
you're in the schedule now, yes.
Indeed.
That's what I was wondering.
And you can see that it sets out that a parent includes any party to a marriage or civil partnership, whether or not subsisting, in relation to whom the child concerned is a child of the family, and any reference to either parent or both parents shall be construed as references to any parent of the child and to all of the child's parents. Now, in our submission, neither partial definition, either that in Article 1 of the Act or that in Article 13 of the paragraph 13 of the schedule, is exhaustive. And that was the approach that the Jersey Court of Appeal took when looking at those 2 definitions. The Jersey Court took the approach that Article 1, firstly, is sufficiently broad to apply to both the biological parent and the legal parent. But the Jersey Court also recognises that the biological and the legal parent may not be the same person. So it's helpful to, or may I invite the Court to look at where the Jersey Court deals with this, the Court of Appeal deals with it in its decision. And this is at MS 12, where the Court considers the scope of the Children Jersey Law 2002. And the central focus of the decision in relation to Article 1 is set out at paragraph 20, where a number of key points are made by the Court. First of all, there's no equivalent to the general definition in the UK or the England and Wales Children Act, and I'll come back to that in a moment when we deal with the issue of T and B, or the decision in T and B. But secondly, in paragraph 20, the Court recognises that the breadth of the phrase father of the child, whether or not he was at any time married to the child's mother.
Of course, it's not the United Kingdom Children Act.
It is the England and Wales Children
Yes.
Act. I accept that point, and I think I referred to it as such a moment ago. You see in paragraph 20 that the Court is looking at the 2 sentences in Article 1 as being disjunctive. So it is the first sentence applying to legal parents, potentially, and the second applying to biological, potentially. You see also that the Court goes on to consider that this leaves open the possibility, and this is the crux of the decision of the Jersey court, that it leaves open the possibility that there may be circumstances which might cause a man to be recognised as a father under Jersey law, despite there being neither biological parentage nor marriage to the child's mother.
I wonder whether too much is being read into the word biological in the interpretation section 1.1, or is it an article? Sorry. Are these articles or sections?
Articles.
Articles, thank you. Article 1.1. The reference to biological father of a child is a reference to Article 5.2, which I don't think you've shown us, Ms. Fottrell. But Article 5.2, which we find on page 535, is dealing where a child is treated in law as legitimate, but somebody other than the husband is the father. He's the biological father, so he can get parental responsibility. And so the reference in the interpretation part of the article to biological father really flows, doesn't it, from Article 5.2, where dealing with a biological father rather than a husband who is treated as, because of the presumption of legitimacy, treated as the father. So if that's right, I wonder whether too much should not be read into the reference to biological in the second half of this interpretation bit.
Well, my Lord, it's helpful to look at how the Jersey court goes on to deal with it, because, of course, specifically in Article 1, there is a reference to Article 5.2, and to that specific point, the biological father not being the person to whom the mother is married, so that if one looks at the consequences of Article 5.2, it seems to permit circumstances where there is a legal father and a biological father may also acquire parental responsibility, and both of those things can coexist at the same time. That's the consequence of Article 5.2. But the reading that the court gives to, forgive me one moment, the reading that the court gives to that provision and the inclusion of the formulation biological father of the child is that it leaves open the possibility, and this is at the bottom of paragraph 20. My Lord sees the sentence that begins, but the breadth of the phrase, father of a child, whether or not he was married at any time to the child's mother, particularly when contrasted with the later formulation, leaves open at least the possibility that there may be circumstances such as...
It has to. Because why on earth, if father only means biological father in the first part of the definition, why bother with the second part at all?
Well, precisely. That is our submission.
I think that was my Lord's point.
That is our submission. That is the interpretation that the court below was invited to take by the respondent, and that is the interpretation that the court did take. What is crucial, we say, is the court is entitled to read the definition in that way. It is entitled to give it a broad interpretation because the definition itself is not exhaustive. And as my lady said a moment ago, if it was only meant to apply to biological parentage, then it would be, we submit, differently drafted.
But it's not just a question of entitlement. You're saying they are correct so to do.
We say that they are correct and they are obliged to do so. Yes. So, my lords and my lady, when one then looks at the basis for the decision of the court, paragraph 20 is crucial as to the interpretation, but one goes on to look at the recognition of the difference between this decision and the T&B decision. So at paragraph 26, and that's MS 13, the court makes it very clear, and it has never been the respondent's case, it makes it very clear that the basis of parentage is either biological or legal. It may include, obviously, social and psychological parentage, but social and psychological parentage would not be sufficient. And to that extent, this decision is consistent with the T&B decision. And then you see the reasons given by the court itself at paragraph 27 as to why it has reached the conclusion it has in relation to definitions. And it gives 5 reasons at the bottom of that page and 4 further reasons on the page over paragraph 14, or page 14. So in relation to the first point that we make, to conclude on that point, we say that the broad reading was a reading which the court was entitled to reach, that it was obliged to reach, but most particularly that this was not about a decision as to biological paternity. It was whether or not a person holding legal parentage, clothed with legal parentage, as a consequence of a decision of a foreign court, could come within the definition of a parent under Schedule 1. May I then move on to the second point that we would like to make out of our list of 4, and that is to deal with the fact that that approach taken by the Jersey court, we say, is consistent with the approach taken in other jurisdictions to the question of legal parentage. And we also say it is compliant with ECHR jurisprudence. Now, I mentioned a moment ago that it was consistent with the decision of the English court in T&B, and the court has already been taken to that decision. But if I could ask you very briefly to look at it again, it is at MS 1209, Volume 3, tab 34. And if we could look particularly at paragraph 55 of the judgment of Mr. Justice Moylan, as he then was, at MS 1224. And you will see that the question that he was asking himself, and we've looked at this already with Mr. Todd, but I want to make 2 points about it, if I may. The question that he was asking himself was as a matter of statutory interpretation, a parent against whom a financial order can be made under Schedule 1 of the England and Wales Children Act was confined to legal parents. And legal parents was either biological parents or parents who had become parents by operation of law. And he goes on at paragraph 60 to reach his conclusion. And his conclusion is that parent under Schedule 1 encompasses the natural parent, by which one means the biological parent, but also legal parent by operation of law. So the HFEA parent, the adoption parent. But we say, as we did a moment ago, that operation of law can also include a decision of a foreign court. Now, it's helpful then, we say, to look at the approach in other jurisdictions, because it is part of the appellant's case that if the Jersey court decision is to stand, that will be in some way either out of step with the general acceptance of the primacy of biology, or it is problematic in the context of Jersey law itself per se. But it's clear from European case law, European Court of Human Rights case law, that voluntary acknowledgement of legal parentage is permitted in many common civil law states, as my lady pointed out to Mr. Todd this morning. It's also clear that where there is voluntary acknowledgement of paternity, biology is not the sole determinative or the determinant of parentage. And if the law permits voluntary acknowledgement, insofar as we were able to discover, no state so far requires scientific evidence of parentage. So many states tolerate and permit a putative father acknowledging parentage. What is then clear also is that applications to disestablish parentage raise particularly difficult issues when the parentage is established in the first place by way of a voluntary acknowledgement. Because a court determining an application to disestablish parentage, as the Latvian court was in this case, has to balance competing public interests, the interests of the child, and indeed the interests of the parents. No hierarchy immediately emerges, save that consistent to the cases, which I'll take the court to in a moment, is that where the application is made in relation to a child while they are a child, the best interests of that child will feature very heavily in the court's determination. And when we talk about best interests of the child in this context, it is very much about the stability of the child's circumstances and the certainty that legal parentage has been determined. Now, it's helpful to recognize that the submissions made on behalf of the appellant, that there is an imperative in relation to biology around disestablishment applications. We say that is simply too reductive. If disestablishment applications were only about biology, then there wouldn't be a necessity to undertake this balancing exercise as to competing interests of the rights holders. And that submission, we say, is made good if one looks at the European Court of Human Rights jurisprudence. And I'd like to take the court to two authorities in particular. Before doing so, I'd make the general submission that what's striking about the ECH or jurisprudence, and there is much of it, is that no clear pattern emerges through European Council of Europe states as to the correct approach to legal parentage. And the consequence of that is, of course, that the European Court of Human Rights grants a wide margin of appreciation to states as to how they deal procedurally and substantively with establishment or disestablishment of parentage. The first decision that I'd like to look at is the case of Kautzner versus Germany, and that is at MS 1001, Authorities Volume 2, tab 24. And the Kautzner decision involved a man who was seeking to establish his own biological paternity in relation to a child who had been acknowledged by another man. But before looking at the substance of the decision itself, there is a helpful summary at paragraph 37, which is page 1007, of a survey or comparative analysis undertaken by the European Court itself as to the different approaches to acknowledgement of parentage and disestablishment of parentage. And we see at paragraph 37 that the court sets out of 26 Council of Europe states, 21 states required the consent of the mother for the voluntary acknowledgement of paternity. 17 states presumed the biological father is entitled to challenge the paternity of a third party, but interestingly, that can be subject to time limits. That is a common feature. In 15 of those 17 member states, this remains the position, the entitlement to challenge the paternity of the third party, where the child has lived with the father in a social and family relationship. And then it goes on to say, in 2 states, France and Spain, it may not be challenged if the child has lived with the father under a particular time limit, that being 5 years. And then 9 member states, the biological father does not have standing to challenge legal parentage. None of the member states provide a procedure to establish biological paternity without formally challenging the recognised father's paternity and without changing the child's legal status. And of course, the significance of that is if the consequence of a challenge is to change the child's legal status, then it will require some consideration of the child's rights and the best interests of the child. Now, looking at the substantive decision in Kautzner itself, at paragraph 63, the court sets out what this decision is essentially about. It primarily revolves around or evolves around the question of whether the applicant...
Sorry, could we have a page?
Forgive me, it is 1012. So the key issue in the case is the question of whether the applicant has a right to have his alleged paternity certified and legally established. So what he was seeking to do in this case was to have the opportunity to present scientific evidence as to his biological paternity. About halfway down page 1012 in paragraph 64, the court recognises that when one is looking at this issue, consideration of what lies in the best interests of the child concerned is paramount in every case of this kind, depending on the nature and seriousness of the child's best interest may override that of the parents. And then at paragraph 67, which is MS 1013, it goes on to note what the position was in relation to German law and the complaint which was being made, that the putative father, or the applicant in that case, complained about the fact that the mother of a child born out of wedlock, by giving or refusing her consent, was in a position to determine which of the 2 potential fathers was granted legal paternity. Secondly, he complained about the fact that he was prevented from pursuing his application further because a substantive or procedural bar was an analysis or an evaluation of the relationship the child had with the legal father. And lastly, he complained about the fact that he was denied the possibility of having his paternity certified without changing the child's legal status. And the European Court dealt with it in the following way. Over the page at 1014, paragraph 71, it makes the point that we dealt with a moment ago, which is comparative research sets out that there is a range or a diversity of approaches to this issue and a lack of consensus. Paragraph 72, that there is a tendency in member states towards allowing the presumed biological father to challenge the legal paternity under circumstances which are comparable to those in the present case, but there is no settled consensus. And then it goes on at paragraph 73 and 74 to consider the balancing exercise, recognising, of course, that the applicant had an interest which engaged the provisions of Article 8, but that had to be balanced, as set out in paragraph 74, against the existing relationship with his legal father. And if one looks then at 76 and 77, it follows that Article 8 can be interpreted as imposing on member states an obligation to examine whether it is in the child's best interests to allow the biological father to establish a relationship with his child. And it goes on to say that in these circumstances, paragraph 77, the alleged biological father must not be completely precluded. And of course, that's not what happened in this case. And ultimately, the court concluded that the domestic authorities, and this is over the page at 1016, paragraphs 81 and 82 and 83, that the domestic authorities had struck the correct balancing exercise in relation to the competing interests of the putative father, the legal father, and the mother of the child, and the child himself. Now,
So where does it take us, the fact that this applicant's human rights were not infringed by his being unable to challenge the other man's paternity and establish his own? Where does that take us in this case?
yes, well, my lord, there are 2 points that we would make about that particular case, and they may be better made if we can look at the second authority I wanted to look at, and I'll make the points together if my lord is content to deal with it in that way. The second authority I wanted to take the court to is a case called AL versus Poland, and the AL decision is at MS 735, and that is tab 2, forgive me, volume 2, tab 14. Volume 1, tab 14.
This is an admissibility decision,
It is indeed.
I take it.
My lady, the reason for looking at this decision, and of course because it is an admissibility decision, it is a relatively brief decision with limited analysis by the court. The relevance of it is that factually it's almost on all fours with the facts in this case. Because this was a case involving a father who, or a man who voluntarily acknowledged the parentage of a child, knowing at the time that he did so that he was unlikely to be the biological father of that child.
So sorry, just on the technical point, I wonder if it is an admissibility decision. It's a judgment, and that paragraph 4, it says they rule on admissibility and merits at the same time.
Could be. I was just going on the presentation, which
Yes.
usually doesn't look like a...
No, it's definitely not
not a normal
heavily
judgment.
reported. No.
Well, if my lord looks at MS, and my lady look at MS 749,
Yeah.
there's the declaration as to admissibility, and then there's the substantive analysis. It is, I would accept, a decision very much in keeping with more recent decisions of the court where the analysis of the substantive issues is relatively...
Yes, declared admissible but no violation. Yeah. Sorry, got it wrong.
Now, in this case, at paragraph 13 and paragraph 19, so this is MS 736, you can see that 13 and 14, he voluntarily decided to recognise his paternity, notwithstanding, as we say, that he knew he may not be the father of the child, and that is set out at paragraph 19, MS 737. And the substantive decision of the court is at 68, 69 and 70. Where the court sets out the factors which fall to be considered in a disestablishment application. And then at paragraphs 77 to 78, applies those factors to the particular facts in this case. And again, there is a primacy given or greater weight given by the domestic court, and that's at the bottom of MS 748, to the interests of the child in maintaining the status quo, than there is in permitting the interests of the applicant in that case to address the question of biological paternity. Now, to return to my lord's question, a moment ago as to what is the relevance of both the Kautzner decision and the AL decision, we say that there is a thread running through those decisions, that there is a balancing exercise to be undertaken between the law, the biology, and the social reality of the child's life, first of all. And secondly, we say that while there is a lack of consensus as to the approach to be taken under domestic law, there is a consensus that where those interests are competing, the child's interests will prevail, particularly if, as we said earlier, the child is a child at the time that the application is made. And
I mean, in a sense, more interesting than, or more significant for us than the findings that there was no breach of these men's human rights is all the material about how it works in Europe.
Indeed. It also, we say, makes it clear that the approach of the Latvian court, the decision which is impugned by the appellant in this case, that the approach of the Latvian court, in other words, where the legal parentage was acquired and maintained, is consistent and compliant with the ECHR. So domestic decisions where primacy are given to the child's best interests and where the public policy underpinning that is the stability and security being served by time limits, being served by recognition and maintenance of voluntary acknowledgement. We say that those are the considerations that emerge from the European Court's jurisprudence. What's also important is the Court has been addressed by Mr. Todd on the significance of the right to identity as that manifests itself generally within Article 8, but also specifically within the UN Convention on the Rights of the Child. And it's clear from these decisions that we've looked at, but from the Court's own survey of European jurisprudence, domestic jurisprudence, that the right to identity is only one of a number of factors which have to be weighed in the balance. And the right to identity can't be simply reduced to knowing one's biological or genetic origins. Identity in relation to parentage is a much broader issue than that. And while Mr. Todd took the Court to Article 7 is the right to name and nationality. It is Article 8 which is the right to identity. And we say that these decisions make it clear that identity is not a trump card if one reads identity as only being about genetic identity, which is the submission, as we understand it, being made by the appellant. Could we move on then to look at the third point from our list? And that is the submission that a decision as to parentage is a decision as to status, and that private international law principles require the Jersey court to recognise that decision. When one reminds oneself of the, or looks again at the decision of the Latvian authorities in December 2006, reinforced by the decision of the Riga court in 2012, the outcome or the consequence of that decision was threefold. First of all, the appellant became the father of the child as a consequence of that registration or re-registration. Secondly, the appellant became one of his parents, his legal parents, as a consequence of that decision. And thirdly, the child himself became the child of the appellant and the respondent. And it's evident that that position set out or achieved as a consequence of the declaration of parentage in 2006 is maintained by the Latvian court subsequently. It's maintained in 2012 and it's maintained in the appeal, or two subsequent appeals. Now, if the Latvian decision is a decision as to status, we say that the Jersey court was obliged to recognise it. And we say that there is a general and well-established rule about recognising status decisions made under foreign law. And I can take the court through a number of specific decisions, but the general rule is set out in the case of Goodman and Goodman, which is in the authorities bundle. Forgive me, it is the loose document that was handed up this morning.
Is the wrong judgment in the electronic file?
Yes, I'm afraid so.
Different case altogether, isn't it, Ms. Foxall?
What was handed up this morning was Patel and Mirza,
Yeah, it was
I
yesterday.
think.
Sorry, Patel and Mirza was handed up this morning.
But
Goodman
another one
was
was.
delivered yesterday in
Oh,
a
right.
small bound copy.
Okay.
So the Goodman and Goodman case is a case which involved a claim to an estate being made as next of kin, where the claimant was an illegitimate child who was later legitimated under Dutch law. And the court held in the Goodman and Goodman case that it was proper to decide and determine kin is in the international law adopted by the Comity of States. So it's a well-established principle, and this is at page 297, about halfway down the page. Begins, the family relation is at the foundation of all society, and it would appear almost an axiom that the family relation, once duly constituted by the law of any civilized country, should be respected and acknowledged by every other member of the great community of nations.
Well, that's terribly wide, isn't it?
Yes?
Is not the ratio adopted by the majority a few lines above on this same page, where Lord Justice James says, the status of a person, his legitimacy or illegitimacy, is to be determined everywhere by the law of the country of his origin, the law under which he was born. Doesn't this case then, isn't it authority for the proposition that because this nephew of the deceased was born in Holland with parents domiciled there, so he had a domicile of origin there, the legitimation decision of the Dutch court, and we had no legitimation recognized in our country at that time, fell to be recognized. Is that correct?
Yes.
So the bit you read out in the course of a very eloquent judgment from Lord Justice James in various respects really is extremely wide, isn't it, Ms. Foxall?
I accept that.
Very well.
We put it in the way that we put it, which is that it is a general articulation of a rule and an established principle, but it may be more helpful to this court to go through specific status decisions.
Well, I mean, we've got to have an eye to domicile of origin.
Yes.
And I suppose you say, well, this child's domicile of origin and domicile at the time of 2006, and for that matter, 2012, was Latvia.
Yes, and as my Lord pointed out this morning in discussions with Mr. Todd, it is also the domicile of the child's mother.
Yes.
So, my Lords and my Lady, if we move on, of course, my Lord, in relation to decisions about this particular child, in this specific case, habitual residence is also the basis of jurisdiction under the Brussels II regulation.
Yeah, but that doesn't apply, does it? It doesn't apply to this situation, and I'm not at all sure whether or not it applies in Jersey. Jersey isn't a member of the EU.
It doesn't apply in Jersey, I'm being told by Mr.
I thought not.
Shall I move on from that point and deal with a number of decisions in relation to recognition of foreign decisions as to status? First of all, and we set these out in our document. But first of all, there are a number of decisions relating to divorce, which of course is now governed by the Family Law Act and the EU regulation. But historically, English courts have recognised foreign decisions in relation to divorce, including the decision of Travers and Holly. I don't think we need to look at that particularly, but for the court's reference, it is Authorities tab 79, page 246. The English courts have also recognised decisions in relation to nullity, and that is in the case of von Lorang and Salveson versus the Administrator of Austrian Property, a decision of 1927, and that's Authorities tab 32. And that is MS 1155. English courts have also recognised decisions in relation to adoption, in particular Valentine's Settlement, Authorities tab 30, and that's MS 1116, and more recently the case of S&S at 1789. Interestingly also, for the purposes of this application, is the Jersey decision of Gutworth, which I would ask the court to look at, which is Authorities tab 65, which is MS 1594. Now, Gutworth is a significant decision because it is, firstly, a Jersey decision, but it is recognition of a foreign adoption, and the circumstances in the case involved an applicant who was applying for a declaration that she could be the beneficiary of a trust. She had become the child of one of the beneficiaries as a consequence of an adoption in New York State, which had been effected when she was aged 35 and the adoptive mother was aged 79. And the Jersey court recognized the adoption because it was valid according to the law of a foreign jurisdiction, and this is MS 1596. It is valid according to a foreign jurisdiction unless it was contrary to public policy. And the mere fact that the adopted person
Well, it would have to be a foreign jurisdiction with a connection to the parties, surely. Couldn't be any old foreign jurisdiction.
Yes, of course. The adoptive mother was a resident of Jersey. And
No, I'm talking about New York.
yes, the child, the adopted person, was a New York resident.
Trouble is, the judgment is so brief, we can't really answer Lady Hale's question, can we?
Well, my lord, it is a brief judgment, but it is significant, and it was cited in the Court of Appeal in this case because of the recognition of status point, first of all. But secondly, and this goes to a different point made by Mr. Todd, it was not possible for an adult to be adopted when they were an adult in Jersey. But the fact that that had occurred in another jurisdiction didn't prevent the Jersey court from recognising the adoption. So it shows a willingness on the part of the Jersey court to recognise foreign status, notwithstanding that the outcome or the status may not be achievable within Jersey itself in the same way. Could I move on then to look at a number of cases?
There was no dispute in that case, was there?
It was by consent or by consensus?
Yes, I think it was.
Yes.
Yes, very well.
My Lord, I accept it's a very short judgment with relatively little explanation, but the mere fact of it is, we say, significant. Could I move on then to look at a number of decisions in relation to paternity, which have been recognised by the English court? And there are 3 in particular, which we say are of assistance. First of all, the decision in the case of Doglioni versus Crispin, which is at MS 954, Authorities tab 20, volume 2. And that case involved a claim by the natural son of a man who died intestate in Portugal. And the Portuguese court held that the man died domiciled in Portugal, not as a noble, so his natural son was entitled to inherit his estate. And it was held in that case at MS 966 that the English probate court was bound by the decision of the foreign court. Forgive me a moment. So about halfway down the page, see the end of the third paragraph. This decision is absolutely binding on the courts of this country. Could I then ask
Sorry, the claim was what?
The claim related to the estate. It was a natural son who was not a legitimate son.
Well, by natural son, you mean illegitimate?
Biological. It was a dispute between the son and the man's sister as to the entitlement to the personal property of the deceased.
Yes, it looks as though there were arguments both of fact, was he in fact the illegitimate son, and as to the scope of Portuguese law as to what followed from
Yes.
that if he was. Okay. Thank you.
But of course, the significance in our submission is the English probate court recognising the foreign determination as to paternity. One looks at MS 968, the paragraph that begins the only part of the proceedings below, to which I think reasonable exception might be made. You see that the judgment there enunciates the decision in Portugal was a bar to any inquiry and therefore ought to have superseded all inquiry here as to the title of the respondent. Could I next ask the court to look briefly at the case of McCartney, which is a decision at Authorities Bundle 5, MS 68. The tab 68, MS 1683. And this case involved a man who had been domiciled in England, who died in Malta, leaving a Maltese fiancé and a daughter who was born 7 months after his death. His fiancée filed a claim in Malta on behalf of the child for a declaration of paternity, but also for maintenance. And that was ultimately granted. And in the English court, it was held that the declaration of paternity determines the status of the child. And this is at page 532, MS 1693, internal page 532. The second paragraph, the claimant contends that the judgment is a judgment in rem and therefore enforceable. The declaration as to paternity determines the status of the child and is clearly in rem, but so far as the judgment imposes any obligation on the assets to meet the 75 a year maintenance, it is notwithstanding its language a mere judgment in personam against the curator appointed to represent the estate. We say, of course, the significance of that judgment is the recognition of the decision in rem as to status relating to paternity. And then the last decision that we would invite the court to look at is the case of Armitage and Nanchen, which is at MS 1436, Authorities tab 54. Volume 4. This was a case which involved an application by a mother to enforce a Swiss maintenance order in England after the Swiss court had determined that the respondent in the case was the father of the child based on serological evidence. It's a decision from 1982. The father challenged the decision, the registration decision, on the basis of public policy, but also procedure in relation to the evidence as to his health and well-being, going to the question of whether he had been capable of fathering a child at the relevant time. And if the court looks at MS 1433,
Can't be that.
1443, the second paragraph at the top of the page, it is perfectly plain in my view, where a foreign decree is made in accordance with the proper procedures of the foreign law, and there is no fraud or similar delinquency involved in the case, the court would reject the decree only if the following law concerned is so offensive to the English conception that it would constitute an infraction of the rules of natural justice in the eye of the English court, and so was to be rejected, not to be the subject of recognition here. Now, my lady and my lords, if we take those cases together, we say that it is clear that English courts, and in the case of Gutworth, the Jersey court, must recognise decisions as to status, subject to a number of principles. First of all, that the decision must be a decision or determinative of an issue in rem, as it is in relation to status. Secondly, that the decision must be taken by a foreign court having jurisdiction over the subject matter. And thirdly, that it must not offend public policy. But of course, public policy is a balancing exercise, and I'll come to that in due course. Now, looking at the application of those principles to this particular case, we submit that it is clear that the Jersey court was entitled in this case, and indeed, as my Lord Hodge pointed out, obliged in this case, to give effect and to recognise the decision, because it was a decision as to status, and it was a decision in rem. We say also in relation to jurisdiction that the court had jurisdiction in the private international law sense arising from domicile. We do not accept the submissions made on the part of the respondent as to the competence of the court to determine this issue, the competence of the Latvian court to determine this issue, because biology was in some way the gateway to the registration. We say that is wrong. That is not what the Latvian law provided. And that then leads one to the question of whether or not there is a public policy basis in this case for the Jersey court not accepting or recognising the decision of the Latvian court. And that leads us on to the fourth point that we wanted to make. How does public policy impact on the question of recognition and ultimately on the question of whether or not this is apparent by operation of law? Now, public policy impacts on this case, in particular in relation to the potential issue of fraud. And if I may deal briefly with that issue as it is put by the appellant, and then I will, if I may, deal with public policy arguments that support recognition, because of course it is a balancing exercise. It is clear from a number of authorities that recognition can occur, and indeed should occur, even where there is fraud, as long as that is fraud as to a substantive issue in the case rather than fraud as to jurisdiction. So if I could ask the court to look at a number of authorities, first of all, the case of Bater, which the court was taken to by Mr. Todd in the context of the Raprasada decision. And
I thought your overweening point here was that fraud hasn't been established, and we couldn't possibly for ourselves fish around and find it proved. That's just simply not our function.
Well,
I thought you were saying that's why it goes out of the window.
That is our primary point. We say there is no fraud in this case. We say that the appellant's case in relation to fraud was not made out. We say that it was rejected by the Latvian court. But even if this court was disturbed by the possibility of fraud, or was to consider that there is some value or weight to the submission that is made in relation to fraud, we say that fraud would not in and of itself prevent recognition.
I don't wish to stop you going through the authorities, but in this case, the Jersey court stayed their proceedings to allow the appellant to challenge the recognition in the country of the domicile of the child.
Yes.
And in those proceedings, the issues of fraud, the issue of fraud was directly relevant.
Yes.
Both to the overturning of the recognition itself and to the time limit. And the issue was determined in that court, or at least the appellant failed to make out fraud. How can a court of Jersey look again at that matter?
Well, as I said, my lord, it's not our primary submission that it ought to.
But how can it? How can we, as an appellate court, open up this question of fact?
Well, my lords, I won't address the court on it.
No, I don't want to tell you, but you're just saying, well, that is your position, but just in case we should change our mind when we walk away from here, then we better look at these authorities.
Well, let me deal with it in this way. we say that the Jersey court took the correct approach in that it recognised the decision of the Latvian court. The determination as to fraud, that being the central element of the appellant's case, was one made by the Latvian court, and the Jersey court took the correct approach. It did not delve into the substance of that decision. But even if there had been a fraud, we say that the court was entitled to recognise the judgment. And I won't deal with it in any great detail if the court doesn't need me to deal with it. There are three authorities that I would direct the court to, and I can give the court the references for them. The first is the Bater and Bater decision, which is at MS 78. I'm sorry, 778. Authorities tab 17. And that is clear as to the issue of fraud in relation to a judgment in rem. The second decision is the case of Perrin and Perrin, which is MS 1769. And the last is the decision of Raparsada and Culloden, which the court has looked at already, but it is at MS 1089. Now, my lords, moving on to deal with the wider public policy issues, and we have addressed this at some length in our document, and this is at MS 512, Public Policy Arguments in Favour of Recognition. Clearly, we say that it is fundamental that the Jersey court respected a decision about legal status in relation to each of the three individuals in this case. Comity and respect for competent judicial processes in foreign courts is obviously a key element of public policy in this case, but also upholding consistency of rights and responsibilities across borders. And that is acknowledged by the Jersey court when it refers to the limping parentage, which goes back perhaps to the point raised by my Lord Kitchen before the luncheon adjournment as to what is the relevance of the appellant in this case pursuing applications in different jurisdictions and asserting different status in different jurisdictions. Limping parentage is, we say, a matter of public policy and one which should underscore the recognition of foreign judgments in relation to status. And also the crucial point of forum shopping in this case, of which we say the appellant has been guilty, seeking to advocate and revisit decisions which have been taken and taken again. But central, of course, to any public policy analysis where the issue is the stability, security, and parentage of a child is the public policy imperative of best interests of that particular child. And when that is weighed in the balance with the other public policy factors which we've identified, we say that all of that leans, and indeed this was the conclusion of the Jersey court, that all of that leans very heavily in favour of recognition. As against that, there is the issue of fraud, which, as we say, the court had determined, and there is a broad submission made under public policy umbrella by the appellant that there is some iniquity arising from the fact that this is an outcome which may not be achievable under Jersey law. We don't accept that, first of all, but if that was weighed in the balance as it was by the Jersey court, we say that wouldn't be sufficient to tip the scales in the balancing exercise, the public policy balancing exercise against recognition.
It's slightly uncomfortable to concede that best interests can affect something like whether a man is legally the father of a child. It's an amorphous concept, an evaluative concept. Can something so wide and flexible inform the crucial, elementary decision he is or is not the father of this child?
We don't rely on best interests as the only public policy argument in favour. There's obviously a broader public policy interest of the community at large, of society at large, in having issues relating to parentage determined and, as it were, stood over and not revisited as a consequence of...
But are we not here looking at whether there are reasons of public policy against recognition? Are we not?
Yes, yes.
We're not looking for reasons for public policy in favour of recognition on your case, because your case is that absent compelling reasons of public policy, the Jersey court was obliged to recognise the decision of the Latvian court.
Yes.
And in that connection, I share my Lord's concern that the best interests of the child are a rather difficult thing to give much weight to, because they do cut both ways. There's the best interests of a child in the maintaining of whatever has been the status quo up till now. That's one interest. But there's always another interest in the individual child, which is knowing the truth about their parentage and their heritage. So it seems to me that without going into the facts of the individual case in some detail, which it's not appropriate to do for this purpose, looking at the best interests of the child as a public policy factor is not likely to help us very much.
Well, Lady, we don't get into public policy objections, which I think is my lady's point, that we're not looking at public policy in a broad general sense. It is objections to public policy or public policy imperatives against recognition, unless there is a clear case in which harm to the public is substantially incontestable. And that is set out in Dicey, if I can ask the court to look at it, at MS 1309. Volume 3.
As far as the public interest is concerned, on the whole, certainty of judgments weighs very heavily compared with considerations relating to the individuals concerned, even if they're children.
Yes. But, my lady, I suppose the question, if I understand it correctly, that my lady is asking is, do we get to public policy arguments against recognition in this case based on the points...
No, I was saying we only get to public policy arguments against recognition. And actually, as I understood it, Mr. Todd's only argument was basically fraud.
Yes, and we say we're not
plus,
there.
Plus some sort of overarching notion that it's all governed by biology.
But if one looks at MS 1309, there's a helpful reminder set out in Dicey at 503 that in English domestic law it is now well settled that the adoption of public policy should only be invoked in clear cases in which the harm to the public is substantially incontestable and does not depend upon the idiosyncratic inferences of a few judicial minds. In the conflict of laws, it is even more necessary that the doctrine should be kept within proper limits. Otherwise, the whole basis of the system is liable to be frustrated. So, in relation to the public policy arguments, if the sum total of the argument is fraud, then I accept and I see my lady's point, which would underscore our submission or accord with our submission that we are not in the realms of a public policy argument against recognition in this case. And that was the approach of the Jersey court. May I make just one observation? Of course, it was part of the consideration by the Jersey court as to recognition, the prominence which had been given to the Latvian court to the issue of this child's best interests when the Latvian court made its determination. So the Jersey court does refer to that fact, but I accept that in the wider public policy context that is not particularly relevant.
Well, as I recall it, but you will know much better than I, the Latvian court defended their 2-year time bar on the basis of the best interests of the children to
Yes.
whom it applied.
Yes.
That's how it came in.
Yes, security and stability.
Security and
Yes.
stability.
Yes.
Mm.
May I just pause there for a moment? Is there anything further that the court would wish me to deal with?
No, thank you.
It appears not, Ms. Rochwell. Thank you very much indeed. Mr. Castle?
I'm grateful, my lady, but no.
Mr. Todd?
Thank you. I may come back on 6 points. The first of them is what happened at the first hearing in Latvia. It's not right that the respondent gave evidence. What happened was her representative, if that's the right word, fulfilled the role as Mackenzie friend, and the respondent made representations and, as part of that, made submissions to the court. And one of the grounds of appeal in Latvia was that those submissions were inconsistent with what the mother had said in her statement. But she didn't give oral evidence. She was not subject to any sort of cross-examination. And neither, of course, was the father. So I thought I'd just clarify that particular point. So rather like the fair point which my Lord Wilson makes, the courts that were looking at this were as badly placed, as indeed this court is, to look at questions of fraud. And yet, the Jersey Court of Appeal did not in any way review this, even though it went at the heart of the jurisdiction. So we have a situation where there has been no oral evidence given at all at any stage. There's been no cross-examination in respect of the issues that underlie the whole of this case. And there is the possibility that the position of the appellant is a factually correct one. And if it is, then there would not be the jurisdiction at all to be dealing with the matters. But there's a much more important point than that, which is to deal with the whole question of whether or not biology is, as I think was said by my lady, biology is the gateway to any such application. We do not say that biology is the gateway to an application. We do say is that where there is a foreign judgment and that it is said that an issue estoppel of the type described in the Carl Zeiss Stiftung case applies, then we need to establish what the issue that was established in Latvia actually was. And that's where the question of the biology becomes important. Not because of its general application, but because of its specific application to this case. It is absolutely clear that the findings of the Latvian court, when they used the shorthand parent, were in the context of it being what Miss Justice Moylan referred to as the third category of parent, i.e. a social parent or a psychological parent, not a biological parent and not a parent by virtue of having been married to the biological mother. We see that on several occasions in the decision, both of the single judge and the appellate judge. One particular example is at MS 327, where at MS 327, in the very final paragraph, the judge there finds in the first sentence, court establishes that the plaintiff could have known since the birth of the child that the child had not originated from him. Well, that is a finding that the child is not the biological child of the appellant. It is that issue which an estoppel arises in respect of. the word parent is something which my learned friends very helpfully took us to a European authority which said there are all manner of potential definitions and how we look at it. Well, when the Jersey court is told you are confined in your exercise of discretion by a prior determination of the Latvian court, then it is fundamental that they discover what that determination was, because it simply isn't enough to say, well, the Latvian court found that there was a parent, and that's the end of it. Because even in England, there are definitions of parent which do not beget claims under Schedule 1. And this is one of those types of parent description. And so we see the description there. It's then also repeated over the page at 328, where it said the child is not his blood child. The court believes this shows that it was not the Court of Jersey where the plaintiff has learned about this, but much earlier, and so on. This is in the third paragraph at 328. And then we know, similarly, in the appellate court, and we see this at 332, 4 paragraphs up, that appellate court agrees to the conclusion of the first instance court that there is no argument that the plaintiff is not the biological father. That is the issue which has been found. So what does Jersey then have to do with the issue that has been found? And the answer is it has to apply it to its own proper law. And when it comes to apply it to its own proper law, it has a closed class of people who may be the subject of being a parent. It would be perverse if a social or psychological parent could be the subject of an order in Jersey, but a Jersey citizen could not. And that is one of the public policy issues that we raise. Any case which departs from that principle is one which is also inconsistent with statute. Because when we look at how parent is defined in the Jersey statute, the particular clause which the Court of Appeal thought empowered them to think of a new category of legally ordained parent is not one which enables them to do that at all. It's the clause which they refer to at MS 12, where they refer to Article 1. And we've already visited that previously, where it says parent includes the father of a child, whether or not he was at any time married to the child's mother, and it looks as if I agree with my learned friend that that's disjunctive, and the biological father of a child where he has been granted parental responsibility. All that appears to deal with is contrasting the situation whereby the father of a child, through the presumption of legitimacy, is liable in respect of that child. If we're wrong about that, then it would be inconceivable that the legislature has permitted these financial claims to be made against a step-parent without it being made absolutely clear. And yet that is the effect of applying the determination of the Latvian court. Because we can break down what the Jersey courts should have been finding very simply. First of all, if it's right that an issue estoppel arises, and we make our points in our case as to why the Carl Zeiss case would say that they wouldn't necessarily apply. It's not a final determination. The true biological father could at some stage disturb the findings, so it's not a final decision, and so on. But if we're wrong about that, and that there is an issue estoppel that arises, then the issue is that he is not the biological father. He might be treated as a parent for the purposes of Latvian law, but that of itself doesn't assist the court in Jersey from discharging its statutory obligation. They need to go on to the next stage to say, well, which category does he fall within? And it's the states of Jersey that determine the categories, and so far they are not expanded to include social or psychological parents. And that is the only category which, applying the issue estoppel, which we don't concede it is, but if there is an issue estoppel from that fear, that is the only category he can fall within. He's not someone with a parenting order, he's not someone who's adopted, he's not someone who's married the mother. And so, if my own friends are right in saying, well, there must be recognition of the status of parent, then that begs the question of what exactly is meant by the word parent in the Latvian context, because it does not translate into the Jersey context without more. If, for example, one was in a state in southern Europe that decided godparents were of such significance in the lives of their godchildren, and that one obtained a declaration to that effect, the mere use of the word parent would not make that godparent, or for that matter a grandparent, susceptible to a Schedule 1 application. Indeed, the powerful judgment of Miss Justice Moylan, as he then was, reinforces the view that even parental responsibility does not put a person in that position. And so simply the use of the shorthand parent is not enough to found it. And the Jersey court didn't go into that investigation, and that in itself made the whole of the matter unsafe. So the public policy matters are not just in respect of the fraud which underlined the whole of the jurisdiction, which needed to be investigated and has never been, or never been properly, but more importantly, it's to do with whether or not this court now is going to permit someone who is accepted by the Latvian court and by both of these litigants to be only in the nature of a step-parent and no more. If a step-parent is to now become the subject of a maintenance order when Parliament has so clearly set itself against extending that jurisdiction to step-parents. For the purposes of these submissions, which are just by way of reply, the question of the 2-year limitation is irrelevant, but the 2-year limitation would, of course, be of significance again when the Jersey court has to consider what the facts are before it, and it is that which is all important for the exercise of the discretion which they have. My lady, my lords, I've already we've dealt with in our case the various other arguments, and I very much appreciate that I'm just rising to my feet at the moment to reply. The primary point that we make is if my lords and my lady is against us in respect of the extent to which an issue estoppel arises, then there has to be analysis of that issue, and it simply does not go far enough to encompass the word parent as is understood in Jersey. My lady, my lords, I don't know if I can assist you much further.
It would appear not, Mr. Todd.
Thank you very much.
Thank you very much indeed. We're grateful to you all for your assistance, and we will take time to consider what advice we will humbly tender to Her Majesty. The board will now adjourn.